Good morning, everyone. Thank you for being here so bright and early on a beautiful day. As Steve mentioned, I'm over at the Department of Justice. We are your law firm. For those of you who are fairly new to the state, we represent all the state agencies and in a variety of different ways. We're divided up into different divisions, and I'm part of the General Counsel Division, which is where we provide general advice to the agency. So we also have a trial division, and they're available to help defend you if there's a problem, and we have other divisions as well, but we're the advice department, and I'm your contact counsel, so if you ever have a question, the questions come through me first, and then I find other people, if I can't answer it, who can respond to the questions. And I've been there quite a while, so I've seen a lot of different kinds of questions. It is great to see all of you. I see a lot of new and young faces, and that is wonderful because I wanted to let you know that at DOJ, in terms of professional liability and potential tort liability, we've got your back. There is a law under the Tort Claims Act that provides that DOJ will defend you. And I'm going to read it to you, and then we're going to parse it out a little bit so that you understand the scope and breadth of how much coverage we can provide to you in terms of legal defense for tort liability. A public body shall indemnify public officers and, let me start again. The governing body of any public body shall defend, save harmless, and indemnify any of its officers, employees, that's you, against any tort claim or demand, whether groundless or otherwise, out of an alleged act or omission occurring in the performance of your duty at work. So let's just talk about that. It's pretty broad. I know there's some consultants in the back of the room, and so unfortunately this doesn't apply to you. But for the rest of the people in the room that are state employees, it does apply. And it should give you a great deal of confidence and assurance that the work that you're doing as engineers at the Department of Transportation, you will be defended for anything that may come up or arise later on. First of all, it says the governing body of any public body shall defend, save harmless, and indemnify any of its officers, employees, or agents. It means that the DOJ will provide your legal defense if you so choose, cover all your legal costs if you so choose, will indemnify, and that means step into the place of you and defend on behalf of the state, and often we will change the name. So if you've been named personally, we'll change the name to the state of Oregon and carry that forward. That doesn't mean, and oftentimes your time spent in the defense of an action is also covered. It's pretty broad and pretty comprehensive. It applies to tort claims. Does anyone know what a tort claim is? I saw a hand move. Oh, it was a wave?
My understanding is that a civil wrong is opposed to a criminal, civil, right. Duty breach, cause, proximate cause, damages, yeah.
It is a civil action for a breach of duty that results in some sort of injury. Injury to property, injury to an individual. We typically see tort claims, at least in my work, automobile accidents that occur. There's a claim because someone's been injured against the state. And this Tort Claim Act will apply to any kind of a tort claim that is filed against the state or maybe you individually for an action that occurred in your duty. as an employee of the state. So it covers alleged acts or omissions occurring in the performance of your duty. Acts or omissions. As engineers, what could that be? Leaving something out. It's omissions, maybe not reviewing something or applying the correct standard. And something happens. It's usually when something happens because there's some sort of an injury that occurred later on. Or an act, maybe maybe there was an affirmative act. You applied a different standard instead of the correct standard in the development of a drawing or the development of a bridge project or something like that. And here's the key. In the performance of duty, in the performance of your duty in employment. So that means that you're acting within the scope of your employment. So if you're working on the side for your cousin Bernie and you're helping him or develop or build a deck, and somehow that deck collapses later on, does this apply? It doesn't. It's only in your act and your performance of your employment at ODOT. So it wouldn't cover any of your moonlighting or any of your arrangements with your relatives on building different kinds of structures. And within ODOT, and I'm sure Steve and others have told you there are policies and procedures, correct? And you are to design to certain standards that ODOT has identified and has provided for you to utilize. That is correct? Correct. I know it's early, but and this is really important because those are the sidebars. So if you're operating and designing within those sidebars, you are operating within the scope of your employment. But if for some reason you wanted to apply this standard over here that hasn't been sanctioned by the agency for whatever reason, maybe really good reasons, but you like it better. It appeals to maybe your aesthetic sense or some other sense. And you apply this standard over here, which is not the standards that are in the range that ODOT has provided. That would be questionable about whether or not you're operating within the scope of your employment. If it was a mistake, a misunderstanding, then maybe there's some room there. But if it was intentional, that would no longer be operating within the scope of your employment. And there is the big exception to the coverage that is provided is we will not cover claims from willful, wanton neglect of duty. And those are pretty powerful words. Does anyone, wanton, that's a great word. Does anyone know or want to provide a definition of wanton? Oh, it's like reckless disregard, heedless maliciousness characterized by extreme recklessness or foolhardiness. So the DOJ and the state will not protect you from actions resulting from extreme recklessness or foolhardiness. So that's a really high bar where we won't step in and assist. And I've never, ever seen anything like that. So, but I just wanted to point out to you that as long as you're working diligently and within the scope of what has been provided for you, the state is available to help defend you if you were ever to be named in some lawsuit later on resulting from an injury from that design. One question I have is, and I know most of you are just beginning at ODOT, so I'm not sure how many of you are stamping drawings. So some of you, a few of you. But what do you think about stamping drawings without reviewing them? You didn't prepare them, but you're stamping them. Would that maybe give rise to recklessness or foolhardiness? Yeah, I think it begins to move into that direction. And so there are things where you don't necessarily have to have a malicious intent, but if you're negligent, extremely negligent, and you're not able to review drawings that you are supposed to be reviewing, there's a whole process of quality control that the agency has established. And if you're part of that a weak link in that quality control, there may be some issues there that we would have to consider. So that's defense for tort liability, and that would arise if there was an injury and a lawsuit filed against the state and or you personally for your contribution or involvement for the events leading up to that injury. A lot of you are in process of getting your license, and some of you have your license. Your professional liability is something that's very different, although because you're working for the state, still very, very important and important to you, but it is different than tort liability. Who is subject to the professional liability? And it's engineers, which is most of you in this room, although I saw a couple of you that are not. And that call themselves, or engineers who call themselves engineers. So if you're an engineer but you're not holding yourself out as an engineer, you're not subject to professional liability. You need to be practicing engineer in order to be licensed. I mean, you must be licensed in order to practice or hold yourself out as an engineer. Who is subject to the practice of engineer are engineers who stamp drawings and documents. And what is the professional standard of duty? Those of you who are professional engineers, you probably know this because you needed to know this in order to pass your exams. So somebody chime in. What do you think your standard of duty is? Well, by stamping the document, you are accepting responsibility for that work product, and you are certifying that that product is in conformance with the standards of professional practice. The standard of professional practice is a factual determination, so it's going to look differently every time we review it, but it's measured at a minimum level of competency, not at the best level of competency. So it's a low bar. And you need to at least pass that very low bar. So questions that have arisen at ODOT is when engineers, as professionals, have differing opinions that perhaps something should be designed to this standard or maybe to this standard. And there's a little given, and there's two different standards, and one individual just doesn't feel comfortable going with the lower standard, even though it may fit into a minimum requirement. Within the agency, there is a process to vet this, and Steve is part of that. And if ultimately you're uncomfortable signing off on those drawings, there is a process within the agency where another engineer can review and may want to assume the responsibility for it. So what I wanted to assure is that there is room, if you're uncomfortable moving forward, there is a process to do so. because your professional liability is your own. We do not defend on your professional liability. That's personal to you. And those kinds of decisions, again, would be personal to you, but there are a number of processes within the agency. I'm also aware that ODOT, through the Chief Engineer's Office as well, works closely with OSBIELs in working through some of these kinds of issues as well to make sure that the standards are at a level that everyone is comfortable with. Just to reassure you, though, on your license, Mike, I have a colleague who represents OSBIELs, and she said the majority of the claims that come through for review, about 50 to 100 each year, are claims for the unauthorized practice of engineering. People who are not certified or don't have their license and are holding themselves out as engineers. That is the bulk of the claims. Sometimes there's a few not representing or calling themselves engineers or working outside of the realm of the area that they're certified in. Or, this is a big one too, failing to meet all of their continuing education requirements. What do they call it in engineering?
Professional development hours.
Yes, your professional development hours. And your license is personal to you, and it's my understanding that the agency is expecting you to make sure that you meet your annual requirements of those professional development hours in order for you to use your stamp. Competency of an engineer rarely comes up before OSBIELs. And when it does, it's pretty egregious. So one example came up when an engineer improperly certified the safety of fire escapes in student housing on a university. Pretty egregious. And another one is an engineer improperly approved temporary extended seating at a sports arena. So all of these individuals were at risk, and apparently there was quite a gap in terms of, well, it was totally missed, and there could have been a huge amount of injury had that collapsed. It's that kind of activity that gives rise to whether or not an engineer is competent to practice at OSBIELs. But that's a different, so your professional license is personal to you, and it's up to you to decide if when you feel you can stamp the drawings, but you need to make sure that all due diligence and focus is on those when you do stamp the drawings. Two different concepts. So Steve wanted me to talk a little bit about another defense that we have under our tort liability. It's called discretionary immunity. And it is a defense that was given to government agencies, recognizing that government agencies are often bound by limitations with their budget and have to make hard decisions. Do we improve this bridge or this bridge? Both are deteriorating. How do we make decisions on allocation of resources? It's also used when you have different policy decisions. We can design a bridge like this, A, or a bridge like B. There's pluses and minuses with each, and you make a decision, a policy decision that we're going to go with this kind of a design versus this kind of design. Typically, you'll have other factors that are influencing or in driving the design result or your decision result. Typically, it's money, or maybe time, or maybe there's environmental concerns out there that you're going to go in one direction in order to protect a resource or to avoid impacting something else. Those kinds of decisions we can defend against, even if there was something that goes wrong later on, as long as we document them as we go along. And what an issue that we've had within ODOT is you're moving pretty quickly and making decisions every single day. And oftentimes we don't take the time to document to say, well, we evaluated X, we evaluated Y, we evaluated Z, and for these reasons we decided to go with a hybrid. And as long as we have it documented, at the time that you're making the decision, it doesn't really work that well when we go back to try to recreate and redocument. We can use that as a defense. It's a qualified defense for something that may ultimately result in a lawsuit, a tort that gets filed against the state at some point. Hopefully, it doesn't occur, but the decision-making process is really, really important. And it's not that simple, and we've been involved in a couple of cases in which documentation was maybe not as robust as we had wanted. And the most definitive case, and we took this to the Oregon Supreme Court, was a case called Turner. A young man was driving his motorcycle northbound on 101 into Depot Bay. If you remember, in Depot Bay, there's angle parking in front of the taffy stores, for those of you who have been on the coast. And there's also side streets that are coming down kind of a mountain, and then intersect with 101. Well, an individual was on one of those side streets and wanted to make a left turn, and because of the angle parking, she needed to move her vehicle out, in order to get enough sight distance, because the angle parking was challenging. And the young man didn't see it. There's a number of issues there, and ran into, or maybe she ran into him, and he's a paraplegic. He was 18, and it's tragic. ODOT had made a decision not to remove that angle parking. It had worked with the local community. It had, and the local community was insistent that they needed that parking for commercial activity. And ODOT had made a decision to allow that parking to remain. But it wasn't documented. I mean, we had individuals that said, oh yeah, that's why we did it. And I mean, certainly there were a number of people that were involved in that process, but we didn't have the decision that said, we evaluated this, we considered this, and we decided to keep the angle parking in that location. There were a number of other issues associated with that as well. There were a number of plans. I think, Lisa, you were involved in some of this litigation. There was a plan to do improvements in that area. ODOT, my background is in planning, so I think planning is great, but plans are plans, and there was no funding to ever implement the plan, and there was never a note in the plan that said, as funds come forward. So there was a plan that said certain improvements were going to be made, but there was no documentation as to when or how or who was going to fund all of that. And those types of improvements would have improved sight distance in that location. So that fact didn't help the ODOT case. And we ended up settling on that. But during the process, and you're only one piece of it, but even in the design of your projects, you will be making a number of different decisions. It doesn't have to be a complicated documentation process, but just a little note would be very helpful if we ever had to come back and have to defend it, that you considered X, you went with Y for these reasons. So I have a half an hour, and I hope you have a lot of questions. Good. No, we would cover any, even if you lose. Typically, what we would do is substitute the agency for you. Okay. But even if we were unable to do that, we would cover any costs and any costs of a settlement or anything that would occur as a result of that. Now, the errors and omissions, I'm going to refer to Steve because I don't know what your policy is, but we cover it under risk management.
Yes.
Yeah.
Errors and omissions, I know our policy really is, I think we're revising the policy right now too, but it comes up through the chief engineer, and the chief engineer makes a determination, or their delegate, whether there was an error or an omission, was standard of care used, and so on the particular situation. I know we do that with any job, consultant work. If there was a situation and there was a claim there, then we would have an evaluation and determine that standard of care, and then move from there.
But individuals who are working for ODOT do not need to carry that because
No.
it's being covered
Correct.
by the agency.
Now, there is a difference, though, if Osbeals feels that when you placed your stamp on there and you violated something within what they're responsible for, then they can take a separate action against you personally. But for the other things, the agency will take you. I had a situation where that occurred. I've had a complaint filed against my license. I was along with the chief engineer as well. It was related to how our stamping policy was laid out at that time, and we were in the process of updating it. But in the meantime, we can't, our strength for defense is that here's our process and we're going to follow it. And then when we change it, then everybody changes. Instead of individually, well, we're working on this, why don't I do it this way or that way? And we don't do it that way. Here's our policy, everybody follows it. So I was following it, even though I knew it was going to get changed, put my stamp on the spec book just before we stamped the individual specs, because that was our process. And then we got a complaint filed against myself for that particular project, and then Kathy Nelson, the chief engineer at the time, for setting that policy. So we went before the board. In the meantime, their investigation took a long time. We changed our policy in between. They made their final decision, and they sent me a letter just to me. It wasn't to the ODOT, saying that you did follow the ODOT policy, but it was a misuse of an engineering stamp, and I got a letter of concern. But that was to me personally, and Kathy Nelson received one as well. And all of our standards, if the standards are not up to date, or there's some negligence or whatever, the chief engineer is ultimately responsible for that, along with the agency. So I make sure now that all of our standards that we set are within the state federal guidelines. And as Bonnie was saying, the bookends that we fall within, they're well within a reasonable standard of care. There are times when an engineer or professional has a personal preference difference. Like here's where we normally do for our reasons, but that individual just doesn't feel comfortable, or they're choosing not to do that. We won't make anyone stamp something they're not personally comfortable with, but we'll probably find someone else that will, because that's within our normal business needs. So, and I want to also wanted to throw out a point there within our standards. Yesterday we were going through, policies and procedures. Headquarters' role is to set all those, and within those policies and procedures is a design exception process or a deviation process. So even though you didn't follow the standard and we deviated or get an exception, we're documenting why we did what we're doing, and there's usually a form and you have to stamp that. And I think for all the ones that go through the traffic roadway group, our state traffic roadway engineer stamps that as well for deviation. You're still within our standards. The deviation and design exceptions is considered to be within our process. So even though we're not meeting that particular one, our standards are set at a lot of them are at the highest level, desirable. But there's a minimum in all of in all the standards, like AASHTO has minimums and desirables. Our standards are desirable, and then there's all that flexibility below. So we're going to have design exceptions or deviations depending on the specific thing. And those are okay as long as you're justifying it, and there's another set of eyes that's going to agree or disagree with you in that process. So you'll be protected that way.
My point is you are all really smart people. And ODOT has a history of having very competent engineering. And we're here to support you and to be available to you if for some reason there's an accident and there's a claim. We're here and we will be able to defend you unless you operate way outside of those standards that have been established, or if you're acting wantonly, which I know none of you will. It's never come up in my experience. But I wanted to let you know that we have you covered. And as long as you're working in that range, I believe that you don't have a whole lot to be concerned about in terms of exposure for tort liability.
I can start that. So the question was, when two engineers have a disagreement on what the standard is, and there's maybe a lower cost situation, who gets to make that call? And when I was a tech center manager out at Region, and I think this is still my expectation, is that the region will have that discussion. The tech center manager will come in and evaluate what the scenario is, and if they can't be resolved by more information at that level, then they would go to the appropriate headquarters section. And now I'm creating that new geotech engineer. So in your example with the geology and geologists, the section manager would be brought in too and hear that, since the standards that they're having a disagreement on are actually, they're the authority on that. So if there was a deviation or what have you, then they would be the ones granting that approval. And if the region, for example, in that scenario didn't agree with that geotech engineer, then they would come talk to the chief engineer and we would have that discussion. But ultimately I would make that final decision.
Does that happen frequently?
Not a lot. Not a lot. Occasionally we get questions, about that, not because two people are having a disagreement. It's more of, hey, the public would like this. What are our options? So we have that kind of a discussion, but usually two different professional of records aren't, we're doing the tiebreaker. Generally that doesn't come up. But that's where if you have those situations, earlier in the process, I'll keep chiming in there, get the headquarters people involved if you're not able to solve that. Sooner in the process we are involved, the more options we have to resolve it. But when we get down to in a 1 week we got a PS&E the job, we need this decision, that's difficult. Your options are kind of limited there. So early in the process is the time to have these discussions. Susan?
So good question. Susan raised the question that what happens in a situation like Tumult Creek, which occurred maybe 10 years ago. Oh, 19 years ago.
Just yesterday.
Just yesterday. And in that situation, if I'm recalling correctly, there was a fish migration going up the creek, salmon that was identified as endangered. And some work was occurring on the creek, and it appeared there was some sort of blockage on the creek. So the fish couldn't go on up. They were stuck. I can't remember, there was some construction project or something that was blocking the creek. So, meaning all good, there were some ODOT employees that were pretty much ferrying some of the fish up past the blockage. Do I have the facts right?
I don't remember if this was when I started, but essentially there was an Endangered Species Act take.
Yes.
And those employees were not protected by DOJ in my recollection.
And that was true. So they were ferrying the fish up. Some of the fish died. Under the Endangered Species Act, that's considered a take. It's a criminal activity. And because we can only defend in the scope of your work, it is assumed that a criminal take is outside the scope of your employment. That makes sense rationally, but under the circumstances that occurred, it didn't make a lot of sense. And since then, we have changed the policy at DOJ that there is an opportunity for something like that to be reviewed by the chief trial counsel, and they can make a determination of whether or not we will defend or not defend. But those individuals were not given DOJ defense because that policy hadn't changed at that point. Because of the nature of the law that was being violated, it was strict liability. There was nothing. There was no room to, there was no latitude. That because it was a criminal activity, DOJ could not defend. And that would be true, it might come up in some of the hazmat stuff too, activities as well, where there's strict liability and there's potential for criminal activity, but potential. That Tumult Creek was very unusual. I think it alarmed a lot of people at DOJ because it was 2 or 3 individuals that ended up having to defend themselves from a claim that was brought on by the federal enforcement agency. And it was very concerning. And as a result, we did try to change the policy to give it a little more latitude, although it's still discretionary. But on the engineering end, we still have you back. And on most of the environmental, I think we've worked through it. I do not remember any other claims, Susan. It was that one. Well, we had that other claim too, but that was a consultant, and that arose, and we took care of that in a different way.
Lawsuits on environmental, but not individual claims.
That's correct. We have had some in the environmental and maintenance arena where, unfortunately, there's a take that occurs with a plant or something else that was inadvertent, but it was documented that something existed there, and for some reason it didn't register, or the activity, they were unaware of it, but they should have been aware of it. And we've had those kinds of situations. And I know that that there's quite an inventory now along the state highways. So if there's ever a doubt, probably best practice is to make sure that you're not dealing with something that is protected.
So with, is it fair to say when we have consultants, we have a contractual relationship and we require the insurance for their liability, but with our own employees, we're kind of self-insured?
That's exactly right. You have to, the tort liability and the defense that we provide is to state employees. So when we have a consultant, we have that contract, And we'll have the, and in those contracts, I'm looking at the consultants, there's usually there always is a provision that, that they will defend their own actions and indemnify the state for anything that may arise that we would defend on our side.
I'll give you the mic, so if you have a couple. I can't remember that much.
So if someone says that their lost property value because of a decision ODOT made, can they file a tort claim?
That would be an inverse condemnation claim, yeah. They can, it's not a, I'm not sure if that's actually a tort or not, but they can file a claim and we defend that.
Okay. And then you talked about holding oneself out as an engineer. How is that defined?
Stamping a drawing when you're not an engineer?
Okay, so as long as you don't stamp anything, then you're not holding yourself out as an engineer.
Or representing yourself as an engineer. If you're doing drawings but not stamping them, you may be holding yourself out as an engineer. Not in your employment, because in your employment, if you're not stamping the drawings and you're and someone else is reviewing it, that's different. But if you're sketching the deck for your cousin Bernie's deck, he doesn't care if it's stamped or not, and you're holding yourself out as an engineer, and the deck fails, that could be an issue. But it wouldn't be in your employment here at ODOT.
And there is a process. We have to make sure it's clear on who's taking on the professional record for something. So if there's
Yes.
two engineers and one's working with another, one will identify that I'm going to be taking engineering responsibility, and they'll, we just want one stamp on the drawing. So
This is the largest engineering firm in
Oregon.
Oregon, isn't it?
That's what
ODOT?
that's what I keep saying. Yeah.
Yeah. So you have lots, and that's the other advantage of, you have lots of people to go to to talk, to confer with, and to work issues out. And that allows for some fairly robust discussion as well.
Yeah, ODOT's been doing this for quite a while, and we do have very experienced staff and have a lot of experience when you're first starting out as a new engineer. It's certain situations, it's about managing the risk, right? Safety is paramount when you put your stamp on there. Public safety is the #1 priority. But sometimes we have to balance the standards and the safety with other things, environmental impacts and so on. And as you practice more and more, you'll have those opportunities to manage that risk, and you'll be taking the advice of a more experienced engineer that's done that maybe a bunch of times, and they'll tell you, here's what you look at, and here's how to find that right balance, that safety standard that you need to hold to, and here's some that you have a little flexibility. And that's what our design exception or deviation process is about as well, justifying and balancing that. But I would encourage you, as you're designing things, as I have done in my career, when, boy, I really don't know if that super that I used was really going to work on something. Well, once it's built, I go out there and drive it, and so I can feel like, wow, that really is okay. The AASHTO book was right this time. If you haven't done it before, you have to kind of experience that out in the field or watch it being built. That's how you get that feedback of, here's what the book says, but here's what the real life situation says. Put those two together. That will help you inform how you're coming up with your decision making and risk taking. So can I refer clarify the example? So let's say you're in a roadway position, but you're in a position that doesn't require a license, but then you get one, and then now you're going to stamp your drawing. I would say that was within the scope of your work, even though your PD doesn't specifically call out your engineering license requirement. You're still working within the scope of what we're asking you to do, and we're knowing. I mean, if you did something out in secret, that would be different. But if your supervisor is aware of it and saying, yes, you can take on that responsibility, which I did when I was younger. Once I got my PE, I wanted to stamp stuff. So, hey, I'll do that job. Yeah, I'll do that. So I felt I was covered underneath that, and I wanted to get that experience. And so I'm
Yeah,
not an
absolutely.
attorney, so I'll let her.
No,
give it-
absolutely. We would absolutely defend you. Unless, for some reason, your supervisor said, do not stamp those drawings, you are not, and directs you not to. But if your supervisor is asking you to do so, even though it may not be in your official position description, we would absolutely defend you.
So first, we're talking legal, so it's all about how you ask the question. So I might not ask this quite right. It might take a couple times. Maybe more for Steve. Yesterday afternoon, I gave the bridge presentation, talked about establishing our design criteria and our standards for the sole purpose of what we're talking about here today. But in the course of my work, I do stuff that's got federal monies, and I do stuff for maintenance that may not have federal monies. And sometimes I guess this is the question, can federal requirements like set what appears to be different bars for an engineer? And this is kind of getting toward maybe a little bit on the minimum standards. We're still applying that professional care, but maybe for the maintenance job, doesn't have that federal requirement. We're still doing, public safety and such. And really, when you see this is maybe in the reverse, if you've spent a lot of time designing federal projects and you think, well, here's the bar, but now we don't have that federal project and the bar maybe is a little lower. Sometimes people have a really uncomfortable, they don't want to do the lesser, even though it's still above minimum.
I think I understand that question. And I think if you have a federal project, then there are certain requirements that are required for that work. But if we're using just state funds, then there are certain requirements that just apply to that, even if they're different. You're still applying the appropriate standard. And within federal and state, I would hope the state standards are still within that standard of care that we need, within AASHTO, for example, which that's what our roadway standards are based on, which is the federal, or kind of, I guess it's not really a federal, but it's on a national type standard level there. And those are all based on research and other things. So I think you would pick the appropriate standard level for your project, and then within those, and it should be clarified in, they can be different. Yeah, they could be.
Have to understand that we're still meeting that minimum, still above
Mm-hmm.
minimum. They can't be different.
Yeah.
It touches on a couple of the questions that are being asked. Some people personally may say, well, I don't feel comfortable stamping that because they're used to doing something at a much higher level, when in reality it's still okay applying that maintenance standard, something like that.
Did I cover that one? Did you want to add anything?
No.
Okay. Okay. You want to add on to that one?
It's always my understanding that federal highways reviews our standards and they approve them and we're certified, so it wouldn't really matter because they're approved by the feds.
Right, and our state standards are based on AASHTO and other national things. So, and they're in that book, so they also review that.
So I'm a geologist, not an engineer, so I'm in the minority in the room, I think. But I am a registered geologist, so I will be professional of record for some things specifically in the hazmat world. And so you called out hazmat as maybe one of the situations where some of the rules are a little different for us. So I'm wondering if you can speak a little bit to liability for professional geologists when we're, say, assessing a property that ODOT may be acquiring and it's contaminated, and we're calling it out as contaminated and potentially causing injury to that property owner.
so the question came up with respect to hazmat assessments. And the question of strict liability comes to the agency around ownership. You own it, you're strictly liable for it. So therefore, if we acquire it and we don't have provisions around it, ODOT ultimately may be subject to remediating it to a level that satisfies the regulators. Individually, I'm not aware of how you might become responsible unless there was something with a spill and you were on the site and it aggravated and but I mean, we're just speculating, and I really don't see, and you were wanton and willful, but I don't really see a situation where you would be responsible. But I'm sure there is something. We could come up with something, but the facts it'd be very fact specific.
That's the thing. Anything legal, you could have a scenario and then change one little piece of it, and the answer might be different. So, but if you're working within your scope, as within your position, and following those procedures, you should be covered under that umbrella.
Right. And the coverage, on the tort liability, it covers all state employees, or all public employees, actually. So, I mean, I was referring to the engineers here, but it's all employees.
Professional records.
That is something we're working with the agency on, is how to tie all of that information to, and it's all electronic now. Oh, I'm sorry. The question was, how long do we retain records where decisions are made? And some records, under your record retention policies, are pretty short-lived, 2 to 3, 4 years, and yet the decision was made affecting a stretch of highway, and perhaps there's an accident that occurs 20 years from now. How do we recover that email that you wrote justifying what you had when we didn't retain that record? And that is something that DOJ is, we have a conversation that we've initiated to make sure we're trying to link your project delivery. Thank you. In a way so that those kinds of decisions are part of that record and we don't lose it. But it's complicated, and it doesn't always work. And it's a really good example of why we would want to ensure that those decisions are documented and carried forward with the design record.
Right. It wasn't just a little long ago we didn't have any way to put all of our folders in. Now we have ProjectWise, so that's going to be where we store our information. That's where construction ultimately is archiving. They have to keep their stuff for 20 years, so that's all going into ProjectWise. So as we develop the phase gates and the project delivery initiative that's documenting the change management process and all of that, some of those decisions should be put in some of those change management requests and things. But as a designer, I would put in any pertinent things that you have related to the design criteria you selected or a decision made. I would put that in your ProjectWise folders so that it could be stored. Because you're right, your email will be just, I think it's every 2 years or something. It'll be removed.
The question was, how does the coverage carry forward when an individual worked for ODOT and then moved on to another firm and is no longer with the agency, and then there's a lawsuit that is filed, and there was a follow-up question to that, which is a little bit different, that then that individual is then stamping drawings for the firm for a project at ODOT. So the first question is the liability goes to the agency, We will defend it. We typically will, if there is an individual named, we will at least attempt to change that out for the liability of the agency. While you were working for the Department of Transportation, that work body is covered. The second question that you have is now you're working, we're working for doing an ODOT project, but as a consultant. That work is covered under the contract that ODOT has with the consulting firm, and the consulting firm should have errors and omissions and would indemnify ODOT for any errors or omissions, any acts that occurred there. But I did want you flag something there that I just wanted to make sure that we address, that while you're working at ODOT on a project and we see some movement and you move to a consulting firm, there is a conflict of interest form and there needs to be a breathing area of room. I think it's 2 years before you can move back on to work that you had at the agency. And that is to avoid conflicts of interest, but also to give you, to protect you and the agency from having a little bit of space in there, just so other eyes can do and assess some of the work.